So you know, Stuart, this morning it was just a little drizzly. I, get into the office nice and early. I get my cup of coffee, and there's nothing better than cozying up with a 55-page opposition filed by Justin Baldoni's team.
Did you make it all the way through it?
I did, yeah.
Yeah.
I just drank my coffee and went through 55 pages of opposition. It was very well drafted.
Okay.
By the Baldoni team, and it's his opposition to
Leslie Sloane.
Leslie Sloane's
Vision
motion to dismiss. Yeah. I know. I almost need to have a board in front of me with all the players.
Yeah. You forget the names.
I do.
Yeah.
I mean, I try not to, but there's like so many of them. It's like two baseball teams coming together.
Yes.
So if you recall, let's, I guess, tee this up. Leslie Sloane filed a motion to be dismissed from the case for the defamation claim. And so she made a number of arguments, and we'll go through what the response to those arguments are. And so she wants out of this case, just like the New York Times wants out of this case, but her arguments, well, a little bit different.
Okay. Well, why don't we pull up the opposition that Justin Baldoni and his team filed today, and you've gone through this. And why don't I just tee up the issues for you, Keith, and then you can fill us in on what's going on. So there was an allegation that there were some group pleadings that were drafted here. And so the Baldoni's lawsuit against Sloane and Vision PR should be thrown out because of these group pleadings. What's that all about?
Yeah, they're just saying that they didn't really specify which plaintiffs were suing what defendants. And really the response to that, and it's a really technical argument, but the response is it's close enough. I mean, you don't have to be exactly perfect when you're going over who's suing who for what. That'll be worked out as part of the lawsuit. So they kind of got rid of that pretty quickly, I thought.
Okay. And then there was a choice of law issue that came up. What about that?
Yeah. So choice of law is kind of an interesting issue because if you recall, the CRD complaint was filed in California. The lawsuit was filed in New York, and there were claims filed in the federal civil complaint by Lively that were both California claims, but some federal claims. There was a countersuit by Justin Baldoni, the Wayfarer parties, under California law, but this is all taking place in New York. So what do you do? It's a hodgepodge. But there are rules that courts use to decide what states' laws they're going to apply. In the New York federal court, they have the power to hear a case and apply it under California law, or they can hear a case and apply it under New York law or Texas law or whatever. So there's two things that you need to know about choice of law, and this is kind of the interesting part. If you go to page 13 of the opposition, the first step in the analysis when there's a choice of law issue is to determine, is there a conflict between the different state laws? Well, that makes sense, because if New York law was the same as California law, then what does it matter? You can just apply New York law, and it won't matter one way or the other. So that's the first step of the analysis. And then the second step of the analysis is going to be which state has a significant interest in the litigation. But before we get to the second step, I did want to just stop briefly on page 14 and show false light. So when you're talking about conflicts of law, so we're asking the question, is the law in California the same as the law in New York? New York doesn't have this. New York does not have a false light claim, but California does. And that's one of the claims that Justin Baldoni brought. Same with civil extortion. In California, you can sue for civil extortion. In New York, you cannot. And defamation's a little different as well. But I just want to bring up false light because it is interesting. It's similar to defamation and libel in that you're actually exposing a person to hatred and contempt. But you're usually doing it by way of an invasion of the right to privacy. So if I were to disclose something embarrassing in your medical records and thereby expose you to hatred, contempt, ridicule, that would be false light. I'm painting you in a false light, and you can sue for that.
Okay.
So let's drop down to page 16. So what does it mean? So the second step of this choice of law is which state has the most important interest in the litigation. And you can see here that they're arguing, Baldoni's arguing that in defamation cases, New York applies the law of the state with the most significant interest in the litigation. And so, under the New York choice of law rules, in defamation cases, the state of the plaintiff's domicile will usually have the most significant relationship to the case. And so, its laws will therefore govern. So, what that means is typically we're looking at, well, where's the plaintiff reside? That's probably the laws we're going to use because that's really where the plaintiff was harmed. If you live in California and you were defamed, that's kind of where you're going to suffer everything that happens from defamation, embarrassment and ridicule and et cetera.
So the interesting thing about this is that if you apply the law of California, the district court sitting in New York, the federal district court, can apply California law if it chooses to do so. And it sounds like Baldoni's crew is saying California law applies because there's this extra cause of action.
Right. 2 extra causes of action. Yeah. So it's looking pretty good that California will probably be the choice of law, but the court's going to have to wrestle with this issue and we'll have to decide this issue as part of deciding on this motion to dismiss on Leslie Jones or Sloane's. Yeah.
Yeah. You got to keep the names right.
I know.
So
it's after lunch. I need my scoreboard.
So then there was also a defamation claim, and Leslie Sloane and Vision PR said that Justin Baldoni did not properly plead the defamation claim. What were your thoughts there as you reviewed Justin Baldoni's response to that argument?
So let's drop down to page 18. And this is defamation under California law, which is kind of what you would expect. And so it's the paragraph that says under California law on page 18. Under California law, defamation is an invasion of the interest in reputation. The tort involves intentional publication of a statement of fact that is false. It can't be privileged, and we talked a little bit about some privileges, and has a natural tendency to injure or which causes special damage. So if you make an assertion of fact that's false and you harm somebody, that's defamation. So that's the definition of defamation that Baldoni wants to use, and it's the one that California applies. So then if we drop down to page 19, I'll show you kind of how they argue this. So Baldoni's saying that, look, as to Baldoni, when you look at what happened to Baldoni, his first amended complaint alleges that the Sloane parties made one or more statements to third parties, including without limitations the New York Times and other news outlets, to the effect that Baldoni is a sexual predator who sexually assaulted Lively, and that Baldoni retaliated against Lively and others for reporting the alleged sexual misconduct, including by propagating false and misleading narratives about Lively for the purpose of damaging her image and reputation. So that's what's alleged in Baldoni's first amended complaint. And it would appear just from that allegation that that's enough to state a cause of action for defamation. That sounds pretty bad if it were true, if it's proven true come time of trial. I think that's going to survive. And then let's drop down to page 21, because there's also an issue when it comes to the Wayfarer party. So then Sloane argues, okay, even if we said something about Baldoni, we didn't specifically say anything about Wayfarer. And the Baldoni's opposition is pointing out that, look, it's not necessary that the world understand what you're saying, that it's libel. It's sufficient if those who know the plaintiff can make out that she is the person meant. So all the statements that were coming out from Sloane, according to Baldoni, you mentioned Baldoni, but you also indirectly implicated Wayfarer by what you were saying, and everybody knew who you were talking about, i.e. Wayfarer. And therefore, that's enough to at least state a claim for defamation. And so that should be able to make it past the motion to dismiss.
So we know we have a motion to dismiss that's been filed by Leslie Sloane and Vision PR. We also know we have another motion to dismiss that's been filed by the New York Times. Do you see a difference between those two motions?
There is a big difference because the New York Times has the right to use the fair reporting privilege, and Sloane does not, because they're not the media, they're not reporters. And so that privilege is limited to members of the media, members of the press. And so they're not going to have that privilege. And so for that reason, I think that their motion to dismiss isn't as strong as the New York Times motion to dismiss based on what we've seen.
What do you think the judge will? Now this has been properly teed up. We have Leslie Sloane and Vision PR's motion has been filed to dismiss the lawsuit against Baldoni. Baldoni's fired back here, said, nope, don't need to dismiss because here are my arguments. Now this goes in front of the judge. What do you think is going to happen with this motion?
And I think the best part of this argument actually is on page 23 at the very bottom. And let me just show that real quick, and that'll answer that question. And it starts with, unless the statement is susceptible. So what they're saying is that normally, so whether a challenge statement declares or implies a provable false assertion of fact is a question of law for the court to decide, unless the statement is susceptible of both an innocent and a libelous meaning, in which case the jury must decide how the statement was understood. And so that's I think the key issue here, is that when you have a statement that is arguably susceptible to an innocent and a libelous meaning, then the jury must decide. And that's the thing that we've kind of been saying all along, is that there's things that are a matter of law that the judge decides, but things that are a matter of fact, the jury must decide. The judge simply doesn't have the right to decide that. And so I think that they have a good chance of overcoming this motion to dismiss, because I think that they've at least pled enough. Now, it's interesting because in this opposition, Baldoni's side does come out and say that they intend to file a motion to amend their complaint. And they did that with the New York Times as well. So now I'm thinking, well, if you're already telling the judge you're going to amend, maybe the judge is going to say, well, why don't you do that before I rule on this motion? And because once you file an amended complaint, all of these 12B6 motions filed by the Times and Leslie Sloane go away. They're moot. And they have to be refiled under the second amended complaint once it's on file. So I suspect that that's what's going to happen. But it's a very thorough brief. It's a very thorough argument, and it looks pretty good in terms of what Baldoni's arguing as against Sloane.
And of course, what we're really waiting for is the opposition by Baldoni's attorneys to the New York Times 12B6 motion. And in that 12B6 motion, again, the New York Times is asking the court, just as a matter of law, throw this lawsuit out that Baldoni has filed against us because we got the reporter's privilege, and it's not defamation in any event because it's an opinion. When we said certain things in our article, those were opinion statements, not fact statements. And so under the law, we deserve to win this, throw it out. So it is going to be interesting to see what his lawyers come up with in trying to defeat the New York Times 12B6 motion.
Yeah, I can't wait to see that one. And we're still waiting to hear back on the protective order, which we talked about quite extensively this morning when we were on with Zach Peter. And that's going to be a very interesting ruling to see what the court does with that.
Okay. So that's our fill of Lively versus Baldoni for today. We also have another issue that's come up, and we wanted to talk about it. And that has to do with something that has only happened 3 times since 1976. I was born in 74, Keith, so it's been a long time. And there's only 3 times that a state in the United States has executed an inmate on death row by firing squad. So there's different methods for killing people, and that's really what we're doing here. We're killing people. They are guilty of a capital offense. So the various states have different rules on this. Some states kill you by the electric chair. Some states kill you by lethal injection. And that seemed to be the wave over the last 20 years or so. It was lethal injection. And lethal injection is not as a good option anymore because many of the manufacturers that make this cocktail of drugs that is given to the inmate who's being executed, they simply won't sell them to the state. And if they find out that any private companies who get these materials, if they then take these these materials and give them to the state, then the manufacturers will not sell them to these private companies any longer. And this really comes from Article 8 or Amendment 8, of the Bill of Rights. And I have Amendment 8 here, and it's in Roman numerals, but it was 1791. And it says excessive bail shall not be required, nor excessive fines imposed. And the important part of this amendment is nor cruel and unusual punishments inflicted. And so people for years have been asking, what is a just way for the state to kill somebody? And it's not easy to kill somebody. Human lives want to live. I mean, it's you actually have to do something sometimes above and beyond to do this. And we've heard about the lethal injections that have gone bad, where it's taken somebody 20, 30 minutes to die and they've groaned. But here at 6 p.m. Eastern time, 3 p.m. Pacific, there's going to be this individual that's going to be strapped into a chair. There were 3 volunteers at the prison that were prison guards that have volunteered to get behind the rifles that are going to be used. And they all will have live ammunition. And they will point these guns at the inmate's heart to the best they can. And they will shoot this individual. So, it's probably a very effective way to kill somebody, but it's kind of a messy way of killing somebody. But I just wanted to ask you a few questions about this, Keith. So here CNN says there's a man that was convicted of a double murder, and he's scheduled to be executed in South Carolina. Note that he did these crimes back in 2001. So we're well over 20 years since he did these crimes. And what he did is awful. He took a baseball bat and he killed his girlfriend's parents. He went into their home and he went in and he used a baseball bat to kill them. So it's obviously terrible what's happened, but it's been well over 20 years ago. His name is Brad Sigmund. His middle name is Keith. So it's Brad Keith Sigmund.
I don't care for that.
And he's 67 and he's just, hours. I mean, what time is it right now? He's 3 hours plus away from being executed. Here's a picture of Mr. Sigmund. Now he looked obviously much different back in the day. And he's gonna be executed by firing squad tonight in South Carolina. What are your thoughts about this story, Keith?
I mean, it seems kind of barbaric, firing squad. I mean, it seems like in this day and age, we should be able to figure out a more, I don't know what, palatable way to carry this out. I mean, it's kind of shocking that that's the way it has to be. It just seems a little barbaric to me. I mean, you and I were talking before we came on about, why not just use fentanyl? I mean, that seems to work really well. And it seems like there's got to be some way to do this in a humane manner. But it is tough when you're looking at somebody who committed such a heinous crime. The other problem that I have with capital punishment is it takes so long, from the crime to finally the punishment. I mean, it's not uncommon for it to be 20, 25 years, 30 years, sometimes never. I mean, it's a long time, and it's because of all the appeal rights. And obviously it's a very big and lasting thing. So it takes 20 years to make your way through all the appeals. Yeah, that's the problem. It literally is all the appeals. And of course, because it's such a finalized punishment,
can't undo it.
Yeah, you can't go back and say, whoops, sorry. It's tough. I mean, I don't like the amount of time it takes to get from, the crime to the punishment.
I think, as a parent, if somebody, God forbid, hurt my son, killed my son in a horrific manner, I would want the death penalty. Absolutely. And I don't care what method, just use any of them, I mean, use them all. I don't care.
Right.
But, if it's not my child and I can stand back objectively and look at this, there are crimes that we certainly think people should be killed for. We have terrorists that are causing problems in the Middle East and other places. And, we kill them. We kill them with Reaper drones. We choose to take these people's lives and remove them from the planet. And so I think there is a line that is crossed. And here you got a guy that took a baseball bat and killed 2 innocent people that had families, people that had children, people that had other relatives, presumably, who would want to spend Christmases with them and Thanksgiving and holidays, and just to have them in their lives. And so these 2 people were not given any of these appellate rights of 20 years. They weren't given any preferential treatment. They were killed horrifically at the hands of a very brutal individual. On the other side of the coin, you have an individual who may have changed in the last 20 some years. I remember when I was in college, there was an execution in Texas when George Bush was the governor still there. And it was an execution, I think this was 97 or 98. It was Carla Faye Tucker. And I just remember her name. She had become a born again Christian over the 20 years that she went through the death penalty process. And she was, just this really kind of diminutive, sweet, kind little lady that when she was younger had obviously committed a horrific crime. In that case, she had literally taken a hammer and hacked somebody to death. She was very young at the time, but I think she was executed when she was 37. So she must have been 17, 18, 19 years old when she committed these crimes. But I remember just resonated with me because that was the first time I really started thinking about the death penalty and should we have the death penalty? People say that we have the death penalty as a deterrent, but I don't think people that go and commit these horrific crimes are thinking in their minds, oh, I might get the death penalty, and so I'm not going to do this crime. So I'm not so sure it's a deterrent. It might be. I don't know. I'm not an expert in this area. But it does seem to me that we've taken a step backwards here tonight if we're shooting somebody in the heart with rifles. It seems a little barbaric to me, and I wish there was a better way to do it.
Well, it's said that he chose this. Like, there's 3 different options, and he chose this one because you could also have the lethal injection or the electric chair, apparently. So I have to assume then that the firing squad has not been deemed unconstitutional under cruel and unusual punishment because they have it. There was a time, I can't remember when was that time period? I think it was in the late 70s when the Supreme
76.
Yeah, the Supreme Court
overruled.
They decided it was unconstitutional, and it stopped all capital punishments for a term of years, and then that was overruled. But so I guess, I mean, if they have a firing squad, that hasn't been challenged, hasn't been deemed unconstitutional by the U.S. Supreme Court, so that must still be considered not under the rubric of cruel and unusual punishment. I don't know why. I mean, maybe it's because it's just a quick death. I don't know. But it seems barbaric to me. And it seems like in this day and age, if we're going to have capital punishment, let's at least figure out a way to do it in a humane fashion where it's not that barbaric, I guess.
Yeah, I think that his lawyers came out and said that he chose the firing squad because it was the least scary one for him to face, because the lethal injection, they've heard stories about people, going through these horrific issues with lethal injection because the states can't get access to the cocktail of drugs they need to do it effectively.
I see.
They still do it effectively. It's just the question of how do they get there. So that's what's going on there.
Well, maybe they should use drones. You said we use drones on terrorists.
Use a Reaper drone.
Yeah.
I think you make some sense. I mean, we do know that heroin or fentanyl does kill people, and it kills a lot of people in the U.S. unintentionally, sometimes intentionally. But it seems to be very effective, and you would think it'd be somewhat painless. I don't know, but it seems like it'd be somewhat painless way to go. So why aren't the states looking at this, and would that pass the muster of the constitutional requirement that you don't have cruel and unusual punishment inflicted on your prisoners in your state system? So who knows? The reason this was interesting to me, though, was because the firing squad is now used in 5 states in the U.S.
Oh, wow. I had no idea.
And one state in particular is actually going to make it the exclusive method of executing people.
That's all you get.
That's all you get. You don't get to choose, and that is the state of Idaho.
Oh, okay.
And why this is somewhat interesting to me is you've got the Bryan Kohberger case. And Bryan Kohberger, if people remember, a couple years ago, he was the student that was at the University of Washington. He was getting a PhD in criminology, and it's only alleged because they still got to prove it, but he's going to be going on trial, and he's alleged to have killed 4 college students in a horrific manner. And then, of course, the police they were able to find his car going back and forth by video in front of the building, and they were able to track him down. They were able to arrest him. And now that case looks like it's going to trial. So if he does get the death penalty, I'm guessing that it'll be under Idaho law. And if it's under Idaho law, is it going to be by firing squad?
By firing, geez. Yeah, and you know a little bit more about this case than I know about it. I heard about it in the news, but why don't you kind of bring us up to speed on this one? There was something to do with the surviving roommates accounts, because there was other people in the house who did survive when the attack was going on.
So this is interesting because we have just some recently unsealed court documents, and that's going to come up later here as we talk about this. But these documents were unsealed, and they have text messages that are going back and forth between 2 of the roommates that survived. And they're panicky text messages. And by the way, the timeline doesn't make a whole lot of sense here, but they're text messages around 4 a.m. and they're saying, hey, something's going on. And I saw a guy that's dressed in black. He had a mask on. He had real bushy eyebrows. But we don't really find the bodies until the next day. And then 911's called at like noon the next day. So I'm not sure why we have this discrepancy. So I want to get to the bottom of the timeline a little better.
That seems odd. I mean, if you see somebody in your house with a mask at 4 a.m., why would you wait till noon to call?
I mean, it may have been that they were in their bedrooms and just scared and didn't come out. And then they thought there wasn't a noise. And so it's like, okay, whatever. And they went to bed. So that's the first thing, is you have these text messages that are giving us an idea of a timeline here. But again, that timeline needs to be developed better. So I'm going to look into that and see if we can develop that better.
Okay. And then what about DNA evidence? I mean, there's got to be something in terms of DNA evidence here if he's truly a suspect and going on trial for this.
So there's 2 pieces of evidence that have DNA associated in this case that we've been able to see. And one of the victims had 3 individuals' DNA under her fingernails. And that's not uncommon. If you walk up against somebody and scratch them a little bit, you could get their DNA under your fingernails. But apparently there was trace DNA evidence that Bryan Kohberger's DNA was under this victim's fingernails. But the lab, and this is taking us back to O.J. Simpson case, where the lab doesn't do things correctly, or they could not come out and conclusively say this is his DNA. And so the defense lawyers have actually filed a motion, and they're seeking to have this particular evidence excluded at the time of trial. So this would never make it in front of the jury for the jury to consider if, in fact, because if there's DNA evidence of his fingernail, of him under one of these victims' fingernails, that's pretty conclusive that he was there.
That'd be huge. I mean, in this day and age, it seems like DNA evidence has gotten really good, and yet they can't figure that out.
So I think there's enough for all of us to agree in the court of public opinion that this DNA evidence is likely his and it's under fingernails, but it's not going to be good enough to put in front of a jury, and the court's going to likely exclude it. And that's a huge win for the defense, but that's not the end of the story. There was also a knife sheath that was left behind. So apparently somebody came in with a knife and a sheath, and they pulled the knife sheath, and then they started killing people, and they left the knife sheath behind. And that does have reportedly DNA that points to Bryan Kohberger, and it's his DNA on that knife sheath. So you win some, you lose some. They may not be able to show that the DNA under the fingernails had something to do with it, but they are more than likely going to be able to put in front of a jury a knife sheath that's found at the scene of the people that have been killed, and it's got his DNA on it. It's going to be
that's pretty strong evidence.
Pretty hard to explain that away.
Yeah. And then what about, are we going to see anything like, insanity defense, anything like that on this case?
So in most of these cases, the lawyers, if they plead insanity, it's usually because they don't have a whole lot more to use as a defense. But apparently you're going to get experts. You're going to get experts on both sides. They're going to come in and testify, one for the defense and one for the prosecutor here. And the defense is saying that Bryan Kohberger was on the autism spectrum. He had an autism spectrum disorder. And so they're saying, hey, he can't, even if he's found guilty of this, you can put him in jail forever. You just can't give him the death penalty. And so I don't know if there's some statute in Idaho they're looking at, or there's something going on there. But the idea is that if a jury were to feel sympathetic that he does have some type, if he's on the spectrum on some level, perhaps that saves him from having to face capital punishment.
It's interesting because it seems like in a lot of these criminal cases, a defendant will plea out, and get a life sentence or something like that, as long as they don't get the death penalty. But if they're not able to escape the death penalty, they seem to go ahead and take them to trial, because I suppose you have nothing to lose at that point. And it seems like it'd be hard in this case for a prosecutor to agree to take the death penalty off the table when you have 4 people who were murdered in cold blood. So I would imagine that they're going to do everything they can to try to defend this, but I can't imagine this being a plea deal.
I think this case is going to trial.
Yeah.
We've talked about Lively versus Baldoni, how that case will likely settle and not go to trial. There's a small chance it goes to trial. I think there's a almost 99% chance this does go to trial. And it's just that there's such a public outcry and outrage about what happened here, and people want justice.
So what's going on in terms of the court filings in this case? Because there's a little bit of issue there.
Well, it was interesting because you know how in Baldoni versus Lively's team has been trying to keep things from the public's eye by using the attorney's eyes only designation or marking things as confidential. The judge actually took both sides to task here, because both sides were excessively using sealed documents to file in this case. And what that means is those documents are not disclosed to the public at large. And so the judge brought them together and kind of banged their heads together, the defense and the prosecution, and said, listen, you can use less restrictive means to protect this information, but the public has a right to know what's going on in this case. And so it was refreshing to see a judge telling the lawyers on both sides, hey, quit playing these games. This is a case that the public is very interested in, and the public has a right to know what's going on. So quit trying to seal everything. Right. Let's get everything out there so people can view it for themselves.
It kind of reminds me of what's going on with Lively and Baldoni too, where, just because you have a protective order is not meant to be used to block the view of bad evidence. It's meant to be used to protect sensitive information like medical information or true trade secrets. It's not there just to hide bad evidence. So it sounds like the attorneys in this criminal case were kind of doing something similar.
I think they are. I'm not sure why the prosecution would be part of this. It may be that they didn't want people to find out how weak the DNA evidence was initially. And again, maybe it's weak on the knife sheath as well. We don't know. From the reports in the press, it appears the DNA evidence is good on the knife sheath. It's just not good on the fingernails underneath the victim. So if they can place him at, sometimes all you need is one piece of evidence in a case. So It sounds like they might have had a richness of two really good pieces of evidence, but they're going to have one. Now, keep in mind, Bryan Kohberger's attorneys will do anything and everything they can to keep that knife sheath out. So hopefully, if in fact he did commit these crimes, hopefully the crime lab did the right work. The people that took chain of custody of the knife sheath, you can prove that, there wasn't anybody out there, like with OJ, there was the argument that blood was planted at various locations. You don't want that to be an issue in this case.
Yeah, I think it's interesting because most judges do take the fact that court hearings are supposed to be public. They take that very seriously, and they don't like to have things sealed unless they now there's times when it's appropriate to seal a court filing for various reasons, but by and large judges do not like that.
Yeah.
They know this is a public forum and they want it to remain a public forum, and that also goes to transparency of the judiciary, and it shows that everybody can go and see what they're doing and feel comfortable that it's going the way that it should.
Yep. So I'm interested from our jury pool out there, if you could please comment on whether you think, what do you think about the Kohberger case? Is it something you want us to cover further? Because we can get into detail on it and give you all of the dirt we're able to pull up. The other thing is, what about the death penalty? What do people think about the death penalty? Obviously, overwhelmingly, Americans support the death penalty. But I'm curious as to what our jury pool would have to say about the death penalty. And if you do agree with the death penalty, what's the method we should be using? Should we use the French guillotine? Should we use hanging? Should we use, whatever is going on there? And then, of course, I thank you for going through a 56-page opposition of Baldoni's attorneys.
Yeah. Well, it's well drafted. I mean, it's always fun to look at good legal drafting, kind of see what the arguments are. You always get a little nugget, even after, I've been practicing 25 years, you're almost the same. And it's always good to read through good pleadings. You always pick up a tip or two.
We'd love to hear your comments on that. And then I'm hearing from producer Eric. Producer Eric has told me that he wants to jump in here and say something. So I'm going to shut up.
Yeah, I'm keeping track of some of the comments here. Wes says if you infringe on someone else's rights, your punishment should be at least be equal to the crime.
I think Wes, you're hitting up on something that has been around for thousands of years. And in fact, if you look at the Christian Bible or the Hebrew Bible in the Old Testament, there are provisions in there that talk about an eye for an eye, right? We've all heard about this before. If you pluck somebody else's eye, they get to pluck your eye out. And so I think that's what you're talking about and saying, look, if you harm somebody and kill them, well, what's good for the goose is good for the gander. What do you think about that, Keith?
Yeah, I mean, I think when I was younger, I was a big proponent of capital punishment. As I've gotten older, I think I've softened on it a little bit because you kind of get to see the gray areas. And, there is an argument to be made that the government itself should not be in the killing business because it sends the wrong message. And so if killing's wrong, then why is the government doing it? But man, it's hard not to want capital punishment when you see some heinous crime that somebody commits and then they get to live the rest of their life in prison, and the victim they victimized, is gone forever. So it's a tough issue. I don't think it's not as black and white as I used to think it was. Now I'm a little bit more, I struggle with it more now than I used to. But I'm like you. I mean, if one of my children was, murdered in some gruesome way, I'd want the person dead. I just would.
I think that all of us can agree, well, most of us will agree that Ted Bundy should have been executed, right?
Yeah, right.
I mean, he was a horrific individual. I think those are the easy cases. I think what you're talking about are the ones where there's somebody murdered, but the question is, well, how much intent was involved in that? Was it just an emotional reaction to finding your wife or husband sleeping around on somebody and you murder them? Should you get the death penalty for that? In one state, you might. In another state, you may not. And I think that's what you're struggling with.
Yeah, it needs to be consistent. And maybe that's the thing, is maybe we need to have a good standard of these are the type of crimes that warrant it, and then these are the type of crimes that don't. So yeah, it's an interesting issue.
Yeah, we got a couple more. I'm just going to fire some of these off here. It definitely seems like a lot of people are interested in that Bryan Kohberger case. T says so. Janae says, yes, please cover the Idaho case. Corey says, would love your guys' opinion on the Menendez brothers case. That's in the news. There's some new kind of, I don't know, rulings and things like that. This was a really great one. We're going to go back to New York Times for a little bit, but everyone seemed to piggyback and like this question. And the question is, if New York Times is let off, does this not open the door for anyone making a false CRD complaint just to report on it using the fair privilege?
Yeah, it kind of does.
Yeah.
Yeah, kind of like, okay, now we have the roadmap. So, the next person who wants to get something into the Times, we now have the roadmap of exactly how to do that and be protected. That's the problem with allegations. People don't understand this. Anybody can allege whatever they want in a court filing, in a complaint. And it can be very frustrating because some of these allegations are quite ridiculous. But your allegations are only allegations. At time of trial, you have to produce actual admissible evidence, and you have to convince a judge or a jury that you're right and the other side's wrong. So allegations ultimately must be put to the test as to whether they're true or not. But it is amazing what people can say. I mean, we've seen all sorts of ridiculous things said in lawsuits as allegations, and then the media can report on it, like the New York Times can report on it and be protected by it. So, on the one hand, it's a good system in the sense that everybody should be able to allege what they need to allege when they go to court and do their lawsuit and do their official business with the court. So it makes sense why we have that rule. But as with all rules, there's instances when the privileges that help protect us can also be abused and, taken a little too far afield. And, unfortunately, I think now we kind of have an idea of, where things can go wrong.
Well, and people have been abusing the legal system for years, but we err on the side of allowing people to bring their claims because we want those claims to be worked out in court rather than in the street, like they were back in the Wild West, where people
a shootout.
Yeah. Aaron Burr comes to mind. But if think about, sometimes there's these huge developers, massive developers, and they're very wealthy and they have a lot of lawyers at their beck and call, and some small person sues that developer can use the legal system to bury that one small person that's suing them. And so there, you have seen some states put in the anti-SLAPP statute, which is meant to help that little person out when they're being attacked by this very large developer, because the developer may be guilty, but if they can make the poor person spend so much time and money responding to their all kinds of lawsuits, well, the lawsuit goes away and it never gets to the merits. And so you do see some states, California being one of them, I think New York also has an anti-SLAPP statute where they're trying to make it where the small person can still file. But even then, people figure out how to use the anti-SLAPP statute in ways that it wasn't intended. Yeah. So there's always the law of unintended consequences that comes from that. It's an arms race at all times. People are going to look at the rules. It's like you pull out a Monopoly set and read the rules. Everybody's going to have a little bit different interpretation of those rules. And that's why when you play Monopoly with one family, there's rules about
the house rules.
The house rules.
Yeah.
And you go home and so it's a little bit different.
There's also something called vexatious litigant statutes. So in California, if somebody files, I think it's 5 or more lawsuits and they don't win, they go nowhere, you can have that person declared a vexatious litigant, and then they can't file with the court unless the court pre-approves their filing. So there is some protection, but.
Yeah, you nailed it. Someone was just making that comment.
Yeah. It's not, yeah, that's right. It's not just one though. You have to file multiple, but if you file multiple lawsuits and you're just always losing because they're always, ridiculous lawsuits, ultimately the court is going to stop you and say, we're not going to let you abuse us anymore. But they are pretty lenient.
Yep.
Again, here's another one. It's kind of on our same topic here. And Janae said, if they go to court, which is a big if, and Justin wins, will Blake Lively be charged with anything? Isn't it a crime to falsely accuse someone?
I think that the court right now is allowing this to be played out on the civil level. So there's a civil case going on. And I don't see anything right now that leads me to believe that the prosecutor's office is going to get involved in this case.
No, I don't think so. I mean, you're allowed to make a complaint to the CRD, and even if it later becomes proven that the complaint was unfounded, or you don't have the claims you thought you did. It's not the same as, I think what this person might be thinking is like when you make a false police report.
Right.
That's a little different because that's a little bit more serious. You're using our, I guess, police officers and government resources. But yeah, you can file a CRD complaint and make allegations. I don't think that she's going to be charged with anything in this case.
There is something that in California, we have a cause of action for malicious prosecution. So if somebody maliciously prosecutes you and you beat them, you can file against them for malicious prosecution, but it's rarely granted. It's there, it's available, it's just rarely granted.
Yeah.
And we're seeing both sides, and we have people in the jury pool who say death penalty should not exist. It seems barbaric. So we're seeing both sides.
Yeah, I think there's plenty of plenty of room to argue both sides of that issue.
All right. Well, listen, it's been a pleasure. Thank you so much for taking the time to spend the afternoon with us. We've been on YouTube all day, so we're tired. We're going to take a break. But we do really appreciate your comments and your questions. So please keep those coming. And we're enjoying going over this stuff.
Yeah, and I'm sure there'll be more to come next week, especially on the Lively versus Baldoni issue and these other cases that we're starting to pick up. So have a good weekend.
Everybody have a great weekend. All right, we'll see you next week.